friends. Hello, hello. I hope everybody's doing fantastic. Tonight we're going to discuss the most interesting immigration news with me, attorney Alina Shaltsova. I'm an attorney from New York. I've been practicing immigration law for 17 years now. I help people not only from New York, but from all 50 states and overseas. And today we will be discussing news with regard to changed USCIS policy, and we're going to talk also about, of course, student visas changes that happened in the last couple of days. Also, you need to know that Foreign Affairs Manual document that codifies the way consular offices have to process visas has been updated, and I'm going to talk about this too. And by the way, the biggest news of today is that Mahmoud Khalil, activist who's been in detention since March 8th, 2025, today was ordered to be released by a federal judge. So thank you very much for joining. My name is Alina Shavtsova. Please like and share the stream. Send me your hearts if you're watching me on TikTok. Send me likes, please, and stars if you're watching me on Facebook. Don't forget to let me know where you're watching from. Don't forget to type up your questions, of course, right? Ask your questions in the comments so that after my presentation, I'll be able to answer them. Immigration questions related to the United States immigration law. And we're going to start. So, guess what happened? Since February of this year, USCIS, they made an announcement themselves. They issued 26,000 of NTAs, notices to appear. This is a charging document that starts once immigration, deportation, or removal proceedings in courts. It means that 26,000 cases were denied at least in this 4 months, 6,500 cases per month. Just so you understand, during Biden administration, generally speaking, USCIS was not doing that. They were not the source of this NTAs, notices to appear. So that's a huge, big change. It means that these days, if you file something with USCIS, at least starting February, right, your case is denied, you will be, if you don't have status at that time of the denial, you will be transferred to court and placed in deportation proceedings, unless you will be fighting for your case further and you will file an appeal or motion to reopen. Just understand that. So when you file an appeal or motion to reopen, appeal does not make the decision on a case final, but motion to reopen, the decision is final, but still USCIS typically would allow you to take your chances with that motion and see what's going to happen. So this is what you need to understand. If you file a case with USCIS right now, or if you have a pending case with USCIS, make sure you have the strongest case possible. Add evidence to it if you can. Prepare it well from the very beginning, all right? So you know what you can qualify for, you know what evidence you should attach, so make sure that you do that, all right? Because this is something very drastic. This has not been happening before this administration, all right? Another important piece of information concerns, of course, student visas. The government of the United States lifted the pause on student visa interviews worldwide, but stated that students must make their profiles, social media profiles, public. And now consular offices must check those social media profiles to see if there is any evidence of that student being hostile or hostile, however you want to pronounce it, towards the United States policies, values, or there are any signs of aggression. Very vague criteria, vague determination. What if you're a friend with somebody who is who went bananas on the internet, but you're just friends with them. Maybe you've known them since they were a kid. And we do not know how all this is going to be resolved, how the assessments are going to be made, how deep or shallow those checks would be. But this is something that you need to know, that from now on, if you're filing for a student visa, which is J1, work and travel program is extremely popular, right? F1 or M, less popular student visa, you will have to make your social media profiles public. If you conceal the information, you will say, well, I don't have my social media. And later it is discovered that you do have your social media. Of course, you will be accused of fraud and with all the consequences, right? Now, Foreign Affairs Manual was updated, and consular officers were instructed as to when they can revoke visas. And one interesting thing there is this: they should not be revoking visas of people who are already in the United States. That's a different department that does it. I think it's maybe helpful. Why? Because apart from the instances when a person was accused of committing DUI or DWI, why it's important, because recently we've seen all this drama when visas were revoked, and they may be revoked by the Department of State, but consular officers cannot revoke the visas. All right, so this is very important to know for the people who are already in the United States. During my latest stream in a couple of days ago, I asked you to guess when you believe the individual hearings are being scheduled for in New York. And I'm going to answer it now. It's 2028 and 2029. So about 3 to 4 years, most judges are scheduling individual hearings in New York 3 to 4 years from now. I think this may be useful information, at least for some of you, right? And the last piece of information is that ICE enforcement is just getting started, it seems. Now they are arresting people at sport events like racing track and some games. I mean, that's truly is disturbing, I have to tell you. But you also need to know about that. Basically, whatever clubs, remember there was an incident at clubs in addition to job sites. So whenever there is a large group of people gathering related to some interest, like gaming or club, somewhere where people, regardless of their immigration status, may attend, ICE may be there. So this is a very interesting piece of information. I honestly have not heard to date that immigration authorities of other countries do that, but now this is what's happening, at least for now. All right. And now, guys, if you have questions, I'll be very happy to answer them. Let me know. Thank you, guys, on TikTok for your hearts and your gifts. Let's see what questions you have. Thank you for joining. Don't forget to follow so that we're going to meet again, right? Because internet is like a wave in the ocean. Today it's here, tomorrow it's not. Hi, Dennis. My husband and I have our interview in July. We just applied in February. Is it a good sign? Recently, the interviews for marriage-based cases were scheduled very, very, very quickly. Okay, so I wouldn't say it's a good sign or a bad sign, but the marriage-based cases are being processed extremely fast. All right. It also means, by the way, that you have to make sure when you file your case, you have good evidence in support of that bona fide marriage, because it's going to be happening quickly. And if you file just the forms and you didn't attach any good evidence, you may face harsh consequences of either Stokes interview, even though Stokes interviews are on the rise, I have to tell you, or maybe flat denial. So just keep that in mind. Prepare very well for that interview. How, Antonio? I got a question. I have an appointment for biometrics with ICE. Can ICE detain me there? I don't think so. I mean, can they, in theory, detain you at the appointment? Yes. But to date, I've never ever seen it. All right. So just you know that I've never seen them doing these things at fingerprint appointments, especially nowadays when they require you to show up for the fingerprints. So it just wouldn't make any sense. Have you had any luck getting a motion to reopen terminated deportation order? Sure. I mean, absolutely. I think in 17 years practicing immigration law, we had only one denial, and we have a couple of those motions pending, but vast majority of the motions would be granted. Sometimes you will have to take a very long road towards your approval. You'll have to first file a motion to reopen, and then you'll have to file an appeal if the motion to reopen is denied. So it depends on where the case ended and qualifications. But another thing is this: if you don't have any chances of reopening your case, we just wouldn't take the case to begin with. So, it's like we take good cases too, and make them stronger, but that's what it is. All right, there are some lawyers who take any case that walks into the door. So, and then of course, there are some lawyers who take the case and then they ask their paralegals to work on the case, and then the case would be denied. So, there are many factors that go into approvals. So, all right. Let me see. Filed jointly, combo interview cancelled, and 400 I-751 after I notified them about my pending divorce. All right. So I guess it's because you will have to amend your I-751, right, to make it waiver-based. So I wouldn't be surprised there. Can I get my I-751 approved if I'm divorced? We have 2 kids. Sure, you still have to prove that your marriage was real and ended in divorce, right? You have to have a final divorce decree, or that you were abused during the marriage, but it was real, or that within the 2 years during which you were a conditional green card holder, occurred some circumstances that now will cause you extreme hardship if the government will try to deport you. So it's called a waiver-based I-751. You can use one or all 3 grounds. I always recommend to file all 3 grounds if you qualify for them, or you may think you qualify for them. Why? Because if you don't declare some of these grounds under the law, if your I-751 is denied, the government must place you in removal proceedings, and the judge will be able to review only the grounds that were presented before USCIS first. It's very important to understand that. Okay. Let's see if we have more questions here. Thank you guys for sharing this stream. I truly appreciate your helping to grow my channel. In CIGIS process, after juvenile court approval, how long is going to take? Well, after the court issues the order of approval, these days, you will have to file I-360 petition, and it usually takes about 6 months, not long. But you will have to wait for your preference visa category to become current for about 4.5 years. Okay, a very long wait. So just keep that in mind. It does take a long time to get that SIG case turned into a green card these days. Hi, John. My asylum case is pending since 2017. What do I do, I guess? Well, listen, pending case is not a denied case, right? So if you would like to try to expedite your case, you can very well prepare request to expedite. You can also file a lawsuit against the government, which I do not recommend these days, but can you? Yes, you can. Okay. Or you can just update your case, make sure that you're prepared for that interview, because I think you will be called within the next year and a half, since nowadays they're cleaning up cases from 2015 and 2016, right? Thank you, Rajesh, very much. Hi, Kira. Right. Hi, Christine. I know that this is challenging time for a lot of us. Do you have any idea if there is going to be an issue renewing work permit? I guess it depends on the category of the work permit. And It depends on the government's policies at the time when you need to renew your work permit. I know that previous Trump's administration tried to cancel some work permit for people who have, let's say, criminal convictions or charges or who cause delays in their cases. So it depends on the category, it depends on where the policies stand. Most people will be able to renew their work permits, should be able to renew their work permits with no issues. However, one thing you need to watch out for is in July, the fees may change. Government fees may change. Remember that law that was passed? I forgot the name of it, but basically, tons of money is going to go to the border offices, and the fees are going to become unbelievable for most immigrants, like $1,000 for asylum, the $900 for appeal, and so on and so forth. So some people may have trouble paying those fees because they will be crazy high if they will become final law. Hi, Ollie. Can ICE arrest someone with overstay who is waiting for the TPS extension? Well, actually, they can. Why do I say that? Because Board of Immigration Appeals issued a decision saying that if you have a TPS pending, it's not grounds to administratively close the case or stop the proceedings because you don't have status yet. But will they do it? Well, I hope they won't. Why? Because if your TPS is granted, then they're going to waste their time on you. So it depends, I guess, also on the situation. If you committed something where you may be not qualifying for TPS anymore, then I think chances of being arrested much higher, right? Hi, Mia. What cities have the best approval rates, both in asylum office and immigration court? Thank you. I wouldn't be able to answer this question because I don't have accurate statistics on that. All I can tell you is that, generally speaking, in immigration courts, you have higher chances of approval than in asylum in asylum offices. That's for sure. And cities, I wouldn't even go by the cities. In immigration courts, you go by the judges, right? And there is a website called Track Immigration. And on that website, you can look up all the judges. And if you are looking for some average, you can see how many judges are in court, in this or that court, and how many of them have a higher approval. Okay, interesting information. How many of them have a higher approval ranking compared to another? And then you'll see 50% of judges from that particular court have 70% approval rate. Then it's a good court, generally speaking. But you can still, even in the best city, draw a judge that has 97% denial. So this statistics is going to be absolutely meaningless for you. All right. Just please understand. All right. Let's see, guys, on TikTok. What do we have? Right. Good evening. Thank you very much, Tony. Thank you, guys, for following. Any litigation with a change of policy for siege in regards of deferred action being rescinded? I haven't heard of that. I wouldn't be able to answer. I wouldn't say yes or no just because I truly do not know. All right. Let's see. Will USCIS start clearing people out of administrative processing soon? It's been a year for a family member. USCIS clearing up of administrative processing. USCIS is not responsible for administrative processing. It is Department of State and it's a consular offices. Administrative processing is when you filed for a visa and instead of getting a decision, approval or denial, they issued 221G, administrative processing, saying that they need to do some research or background checks. So you can do something about that. Your family members can, but there is no deadline as to when consular officer has to make a decision. That's just what it is. Okay. I, Espito, verbal approval, but no update for marriage-based interview. It happens sometimes that the officer stated that he's going to approve the case. All I can tell you is that until you get that approval in writing, their promises are meaningless. Thank you very much for the roses, guys. Thank you. Oh my gators. Sounds like interesting nickname. Hi Abel, I passed my citizenship test, but my approval is pending. I lose my residency? No, you will not lose your residency just because you haven't received N400 approval. That's not true. All right. How is citizenship process? It takes about 6 to 7 months if you don't have a waiver to go through the citizenship process. So it's pretty fast. All right. Pretty fast. Thank you, Cesar Ramirez, for the gift. Let's see. What about going to banned countries with green card? Banned countries. Well, if you're a green card holder and you're from a banned country, you should be fine. There is an exception for that. All right? Yep. Can you tell me who wrote and signed the bill into the law for faster deportations without due process? All right. Who wrote and signed? I have no idea, but that's not a new law. The expedited removal proceedings. The provision is very old one. The difference is how this or that administration implements it. Okay. So under Biden administration, under Obama administration, they use this expedited removal process only for people who they meet at the border or within the border 100-mile radius. But the law does say that for some people who after entering the United States without inspection, who spent less than 2 years in the United States, they may be subject to expedited removal, that quick removal proceedings. And this administration decided just to seize the opportunity to use it. Can they do it? I mean, yes, they can. That's just the law, and they have administrative power to do that. But what happened here also is that they stated people who entered on parole, almost like 1 million of them, right, at this point, also are going to be considered as people who entered without inspection, which is not entirely correct. Parole is not inspection, but it is an authorization by the government to enter the United States. So they cannot be equaled to the people who entered between the ports of entry. That's the problem. And, right now, unfortunately, there is no good record by the government following the judge's orders. We just saw how the Attorney General of Florida got sanctioned by the courts for not following the judge's orders. So it's a tough situation, tough situation. How long does it take to get citizenship interview? About 6.5 to 7 months. All right. So let's see. Which year's asylum cases are going now? Well, I've seen recently a lot of cases from 2015 and 2016 being scheduled. All right. So that's just what it is. But again, you may be called for the interview even if you filed your case later than that. Please understand. It's a random process, and truly, I feel like nobody truly controls it, right? Hi, Faisal. I've been granted asylum for over a year, but I know there is a pause on the green cards for asylees. How protected am I when traveling domestically? Should I worry about ICE detaining me? Well, under USCIS adjudication manual, asylum status is a lawful status. So you shouldn't worry that just because you receive asylum, you will be detained by ICE. If, however, you commit something or committed something that gives rise grounds to believe you can lose your status, then they can probably detain you if you become a danger to public or danger to public, to the national security, then sure, they can detain you. ICE can detain green card, even green card holders, right? Under certain circumstances. So typically, an asylee has nothing to worry about, typically. But what's going to happen, and I believe it will happen, is that current government, will try to see how not to give green cards to all these asylees. And one tool that they may use against you is the notice of intent to terminate your asylum status if they believe the country conditions in your home country change so that you no longer fear or should no longer fear going back. This is very serious, and I think they will use it. Well, we're going to see in a couple of months, right, as to what's going to happen. But I'm pretty sure they created this force exactly for that reason, to develop policies as to how to go about denying green cards under some what we call color of law. Okay. Hi, Maria. What should I do? I have a work permit and nobody wants to hire me because I'm not a US citizen. I'm sorry to hear that, Maria. There are certain jobs that if you don't have US citizenship, an employer can legitimately deny you that employment opportunity. But for most jobs, it's not the case. And if you do have a work permit and the job that you're filing for does not require you to be a US citizen, what's going to happen is that you can file a complaint with the Department of Justice about discrimination. Some very large prominent companies sometimes can get into trouble for discriminating against holders of the work permits. All right. And then they have to settle those complaints by the Department of Justice. All right. Okay. Hi, Raymond. My question is, if I-130 is approved and the removal proceedings are terminated in court, can USCIS conduct another interview for I-45? They will. Not only they can, they will. These days, the court may question your I-130 even after it is approved. I do not know why, but that's interesting how it works. And USCIS will call you for the interview in connection with I-45, right? Hi, Sayak. Finally, my interview was scheduled after 10 years. I submitted my case less than 1 year. Well, it's either less than 1 year or 10 years. So, what was it, Sayak? Tell me. Hi, PH. How long we should wait for N400 interview after biometrics? About 6 to 7 months usually. Yeah. Biometrics is not a marker by any means because lots of people are going to have those biometrics waived. Hi, Dennis. I applied for the asylum. Okay, so I filed asylum application. It's been more than a month already, but my meter still does not run. Your meter still doesn't run. Which meter? If you filed asylum with USCIS, you need to wait for your asylum receipt. And your 180 days started running, all right? If you filed with the court, I guess in court, you will see the asylum clock, okay? Thank you very much, Ceci, for your gift. But, I do not know based on what you believe that something is not running. You let me know what happened, okay? Because a month ago, you wouldn't be filing yet for the work permit to find out what information USCIS has about you. So something else is happening, right? How is the situation at USCIS? Are seekers detained now after interview? No. Not everybody gets detained. Please know that. And of course, some USCIS officers have better reputation than others. And not everybody is going to be detained. Sometimes even people with removal orders who go through I-130 interviews are not going to be detained. So you have to get prepared and speak with your attorney. Of course, the enforcement policies may change, even in the better jurisdictions, but so far, no, you will not necessarily be detained if you're appearing for that interview. Okay, let's see. How to prove immigration if marriage is bona fide? Well, immigration tells that themselves what they want to see. If you look at the instructions to the Form I-130s, they tell you what evidence they would like to see. They start with common lease, under joint lease, what they call uh, joint bank accounts, credit card statements under both names, utility bills, photographs, affidavits by friends and family members attesting to the validity of your marriage. So they tell you themselves. Basically, you have to document your relationship. You cannot attach videos, but you can attach photos and you can attach copies of the documents. All right. Okay. Hi, Le Creole Hospital. Can I travel to Haiti with an extension 48 months, please? I guess you filed for citizenship or removal of condition I-751, right? You should be able. Yes, I would say that you should be able to do that because you're probably, it seems to me, a permanent resident, right? And for you there is an exception, so you should be fine, even if something happens with other people who are non-immigrants. Hi, Noha. All right, I think we dealt with that question about juvenile court, right? Let's see. Is humanitarian parole for Afghans included in the travel ban? Was it exempt? I'm waiting for my visa. Humanitarian parole, I don't think will be approved, but visa for people who are special immigrants will be approved. And those who receive derivative status as asylees or refugees, that will be approved. So if you're referring to that, you shouldn't be affected, all right? People who receive refugee or asylee status through relatives, okay? Hi, Peace on Earth, thank you very much for your gift. Have you ever got a case where 212H waiver was granted with adjustment of status for crime and both inadmissible and deportable, and DHS using the deportable ground because 212H is for inadmissible? Never. I've never had that. Usually if you got the case waiver approved, it's approved, right? They haven't been that elaborate yet. So you should be fine, I think. I think you, not the first time you're asking this question, I think you're very worried about this situation, but I would say that generally speaking, you should be fine, okay? Hi, Kids Hut. I requested the expedited I-131 and was told I need to come in with documents. That's correct. I'm on a pending asylum and approved I-130, which I was advised to do consular processing. Okay. It may be that you do need to do consular processing when you don't have that legal entry, right? And as to I-131, you will have to come in and show that your case is urgent, right? And you have to bring proof. So that's a normal procedure. You have to come in person, right? Do you recommend filing for Mandamus for pending asylum cases in 2020? 2020, first of all, is a very recent filing. And second, Mia, at the beginning, I said I do not recommend filing Mandamus. Why? Because the government will be retaliating against you. Only if you have a bulletproof case. And only then you can try. But I wouldn't even be filing right now if your case was filed only in 2020. Why? There was a decision when a person whose case was filed 4 years ago submitted Mandamus and he got denied. So he wasted all his money on that lawyer, wasted his time, and got denied. Another thing that may happen is when you file Mandamus, the government says, okay, we're going to give you interview in September of 2028. Technically, they gave you your interview, and again, you wasted your money. So if I were you, I wouldn't be doing it. I'm just giving you my best advice. Unless you have very compelling circumstances, all right? Sometimes it's worth it, but it depends on the personal situation. Hi, I'm Rod. How long after interview for I-130 to get a response? It's been 2 weeks. There is no deadline, unfortunately, and it may take months to get the response. And that's what it is. Okay, there is no interview. A congressman is the best person to help in such a situation. All right, congressman. All right, guys, I'm going to answer one last question before I'll have to part tonight. Let's see. What do we have? Mandamus, no, we do not recommend. Hi, Vlad. A green card holder from 1993 to 2003 removed due to a conviction likely considered an aggravated felony. Granted withholding or removal in 2005 and now married to a US citizen wife with a pending, something is pending. Okay. I-130. Okay. All right. So, Vlad, I do not know, why you were convicted, but you need to know that, first of all, like you will have to reopen those removal proceedings most likely, especially because you had a green card, and see if you can qualify for the waiver. But if a conviction is an aggravated felony, there is only one instance where it can be dealt with by I-212H waiver is when the conviction is also a crime of moral turpitude. All right, that I can tell you. The rest, if you would like me to consult you, please come in. We can look at your documents, at your chances for the waivers and everything. And you'll have to file a motion to reopen most likely. If you do that, you may lose that withholding or removal protection. And I do not know if you would want to take that risk with this administration. But again, consult with a couple of lawyers, see what's the best strategy for you. All right? Because that's a serious matter. You do not want to be deported and leave your wife here by herself and potentially children. All right, hi, MD. I applied for I-45 through VAWA last year, March 2024. Which one is still pending? So what is my status? Adjustment of status pending. And if you had I-360 granted previously, you should have a deferred action. So you should be okay, hopefully. Well, guys, thank you very much for joining. Thank you very much for following and liking and sharing the stream. If you find it helpful, please join my social media so we can meet again. I hope you're all going to be safe, healthy, and happy during this weekend. It's set to be beautiful in terms of weather on Long Island, where I live this weekend. We're going to see if it's going to turn out to be this way. But for now, I have to say thank you and goodbye. I'm going to see you hopefully on Tuesday night. Thank you very much.